How can a father lose custody in a custody battle? Well, my name is Akiba Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Now, how can a person lose custody in a custody battle? Well, I'll tell you. Number one, you can fail to follow the existing parenting time or support orders. That's a great way to get the court to say, you know what, this person doesn't seem to care about my orders, so I'm not going to vest him with custody and rely that he will comply with the parenting time. I don't think he's going to do it. Why? Because he hasn't listened to my orders so far. So you got to realize that the court thinks like that. So therefore, it's very, very important to comply with existing temporary visitation orders and support orders. Not doing that is a surefire way to get the court to have no faith in your ability to follow orders. That's a good way to lose custody. Number two, another great way to lose custody, the other side has a documented evidentiary trail of alcohol and drug abuse on your part, okay? If you're doing that and you're doing it and they have documentation to show, not just an allegation that you do it, but you're actually doing it and they got proof, don't expect an easy road toward getting custody of your kids. The court takes some things seriously and some not. I will tell you that alcohol and drug abuse, the court takes very seriously. If there's documented evidence that you are abusing those substances, you can expect that to weigh heavily against you in a subsequent custody case. If you have unstable housing or frequent job changes, that's going to cut against you. That's a good way to lose your case, because think about it. If the court on one side has somebody who's got a stable job, lived in the same place for 20 years, a solid working person, on the other hand, a person who can't hold a job, bounces from house to house, eviction after eviction, residence after residence, who would you pick? I mean, if the court's is looking for stability for these minor children, the court's going to go with the most stable situation. If you've got an unstable situation, that's a surefire way to have votes against you in an ultimate custody case. Also, if there's evidence that show that you're not overly interested in your child, that's going to cut against you in a custody case. If they can show overwhelmingly that you take no interest in the medical condition of the child, the housing condition of the child, no interest in academics at all, no interest in the extracurricular activities of the child, you're a no-show on all those things, don't come crying to the court that you lost custody. The court is doing what is essentially already going on. The court's giving you no interest in your child. Why? Because you've exhibited no interest in your child. You exhibit great interest in your child. The court gives you great interest in the future of your child. It's very simple mathematics. 1 + 1 is going to equal 2. 1 + 1 is not going to equal 3. And a -1 and a -1, that's always going to be a negative. Right? So you're in that situation where you're either getting 0 or negative. Don't expect a positive result. Think of it that way. It's garbage in, garbage out. If you're not putting forth a good effort to be part of your child's life, the verdict of the court will probably be that you don't have much of an impact in your child's life. You don't have much involvement. You don't have much involvement before. The court's not about to give you great involvement afterwards. So it's really a rather simple analysis. You got to look at it that way, and then you'll know what to do in terms of how you should conduct yourself leading up to the custody hearing and how you should conduct yourself afterwards. So in other words, if you're someone who hasn't had a lot of involvement, step up your involvement. Go to the doctors. Go to the extracurricular activities of the child. Show up to parent-teacher conferences. Show that you want to have the involvement. If you want to have the involvement, the way to do it is, the time to do it is before the court already orders that you have 0, okay? Don't play catch-up on this. Get ahead of it, know what you have to do, and then the likely result will be much better. If you have any questions about your particular case, reach out. We'll be glad to help you out.
248-58